The Walt Disney Company got so much bad press from trying to imply that they can force arbitration on anyone who has a Disney Plus account that they finally backed off and waived their right of arbitration before the courts ruled on it. Maybe they knew that it could set a bad precedent. We had to update this story while it was in process, but we still wanted to share what the implications that this had gone through with you here on That Park Place. Hello, I am Jonas J. Campbell, an investigative reporter for That Park Place. I just want to give you a brief introduction. News dropped while this story was going on, saying that Disney waives arbitration in an allergy death at restaurant in Orlando Park. Matter can proceed in court. It was Josh Tomorrow that ended up making the announcement there, and you can see that all over Twitter. He says, at Disney, we strive to put humanity above all considerations. Unless you're shooting Mulan. Disney Experiences Chairman Josh Tomorrow said in a statement, I maybe misquoted him a little bit there, with such unique circumstances as the ones in this case, we believe the situation warrants a sensitive approach to expedite a resolution for the family who have experienced such a painful loss. As such, we've decided to waive our right to arbitration and have the matter proceed in court. Piccolo's lawyers have said that Disney's terms of service argument bordered on the surreal and is so outrageously unreasonable and unfair to shock the judicial conscience. In effect, Piccolo's attorneys said Walt Disney Parks and Resorts is explicitly seeking to bar its 150 million Disney Plus subscribers from ever prosecuting a wrongful death case against it in front of a jury, even if the case facts have nothing to do with Disney Plus. Let's get to the conversation with legendary lawyer Ron Coleman right now. Here with me is a man who I refer to as a legendary lawyer, and I have yet to be proven incorrect on that, Mr. Ron Coleman.
Yes, the legend of Ron Coleman. Who hasn't heard that story told around the campfire? Chilly August night and deep in the woods.
If you get real quiet around the campfire, you can hear the phrase whispered on the wind, we consider this matter resolved.
Very good. All right, I'll give you that one.
For those of you who don't know who Ron Coleman is, he works in the Dillon Law Group. He has successfully argued cases before the Supreme Court, and he has a YouTube channel. So you have access to him and his wealth of knowledge and, dare I say, wit at a moment's notice if you go over there to the Ron Coleman YouTube
you really
channel,
should.
Which would be linked.
Charge.
Not yet. Perhaps we'll have memberships on your channel at some point.
Oh, no, those we have, but I have to pay.
Well, to get on with the show here, let's talk about this case here. To put this in brief here, forgive the pun. This is a case where a young woman, her name is Kanokporn Tangsuan, went to go eat with her husband at the Raglan Road restaurant, which is inside of Disney Springs. And while they were there, the husband alleges that they ate there, and then an hour later, she passed away, very unfortunately, of anaphylaxis, otherwise known as an allergic reaction to something that was eaten inside of the Raglan Road pub. This is a Disney Springs location, and most of the locations within Disney Springs are rented as opposed to owned by Disney proper. But in order to book at one of these restaurants, generally speaking, you have to go through Disney's own app in order to do that, and it would probably be booked through the same travel package as theme park tickets and other items like that. And this right here, in the Circuit Court of the Ninth Judicial Circuit in and for Orange County, Florida, this is a motion to compel arbitration and stay case. If I'm understanding this correctly, the Disney company is trying to say that this should not go to court because there is a case for arbitration, and that, in fact, the husband of the deceased agreed to said arbitration here. A little bit of background, which we are going to ignore here, but here, Piccolo accepted the Disney Plus subscriber agreement and completed registration via the web, provided personal information, including his email address, password, and he had to agree to the terms of service.
Jonas, let's play super stupid here. Let's assume that my mom, is watching this, and she's not a regular viewer of your channel. She's not into Disney. Disney Plus, is that a place? Is that a restaurant?
Disney Plus is a streaming service where people watch TV shows and movies, or at least they used to. Exactly. May the acolyte rest in peace. And this one in particular, this account was created in 2019. I don't see it in the text here, but I do believe this was a free trial of Disney Plus. So not even a monetary relationship was established at this point, but as part of the terms and conditions. Down here, it says in the first page of the subscriber agreement in all capital letters that any dispute between you and us, except for small claims, is subject to a class action waiver and must be resolved by individual binding arbitration. And also states in the same font, that's very important that it be the same font. When you create a Disney Plus or ESPN Plus account, you also agree to the Walt Disney Company's terms of use. So terms of use for using anything, I guess, that the Disney company makes here. And later on, there's a case made here that when he buys tickets through the My Disney Experience app or web portal or however he does it, that he certifies that he has the right to do so on behalf of anyone that he is buying tickets for, especially minors. Here it is, for whom you are purchasing or otherwise securing benefits or managing those benefits and entitlements such as tickets, that you represent that you have all the necessary rights and consents to agree to those terms on behalf of your party. Forgive me for saying it quickly. I want to say it completely and also say that it is both significant and insignificant at the same time. With all of that out of the way, Ron, this sounds like a disaster if the judge agrees to compel arbitration in this case.
Well, it would only be a disaster in the sense that one judge in a Florida circuit court, a state court judge, will have ruled preposterously that any time you cross-refer to the Disney terms of service to buy Mickey Mouse ears or to buy a pretzel on Main Street or whatever it is, you have now, for all time, and with respect to all possible transactions, whether voluntary or otherwise. In other words, if you're walking across Fifth Avenue, New York, and the Disney store vomits out on top of you, God knows what.
A flurry of plush.
Because, right. Or perhaps even a furry.
Hopefully they don't have those, and yet they do.
I know you can be quite sure they do. No, that's preposterous. No judge is going to uphold that. But if a judge were to uphold it, it would still be merely one state court judge whose opinion would not only not be binding on other states, it would not be binding on other cases, it wouldn't even be binding on this judge himself in this court. It's not like an appellate decision. And in fact, if the judge were to rule this way and compel arbitration, it would inevitably be appealed by the plaintiff's lawyer. That's a case that I would gladly take on myself if the plaintiff's lawyer is not in the mood for it, to the Florida Court of Intermediate Courts, and eventually to the Florida Supreme Court if necessary, where ultimately it would be reversed. In my humble, not admitted in the state of Florida opinion, not even very humble either, but that's my view of the matter.
Well, maybe one day you can be one of those retirees that goes to Florida and is the reason for all of those Florida laws that try to restrict the movement of lawyers from New York to Florida. The situation. Well, yeah, the situation that goes through my head here, I think about the competition here, and I've contemplated this in other videos, but now we're contemplating it with a little bit more legal authority, more than a little. So Comcast, who owns the theme park down the street from Disney, the Universal Studios theme park, Islands of Adventure, and soon to be Epic Universe. They're also a utility. For lack of a better term, they are a legal monopoly in internet because they are a large portion of the nation's internet service provider, and in some cases, the only game in town. So I'm fairly certain if I go comb through... Yeah, if I go through the Comcast terms of service for Xfinity, their internet service, I'm fairly certain I would find a compelled arbitration clause that is not too dissimilar from Disney's at this point. At what point do you think it becomes, I don't want to say a Supreme Court level issue here for these compelled arbitration issues to end up to where there's legislation pushing back on this? Because if you have basically a third of the nation, let's say, we've got 100 million people who have essentially no other option for internet except another company that also would compel an arbitration clause, and they're down at, I don't know what theme park, whether it's the one in Hollywood or whatever, and something goes wrong, God forbid.
And
do these people really have a choice?
Wrong.
Right. When people essentially don't have a choice.
You're asking really the fundamental question on mandatory arbitration, which the Supreme Court of the United States has upheld which is routinely upheld despite a gazillion arguments that I didn't really have a choice. It's what's called the contract of adhesion. I wasn't able to get this service without agreeing to that term. Answer, tough luck. Arbitration clauses are favored in the federal courts, and it will be enhanced in the federal courts and in the state courts in every state. But see the books behind me. None of them is a law book. But if they were law books, I would be able to tell you that all the cases involving interpretation of the scope of arbitration clauses would not fit on the shelves behind me, okay? There's no need for any of this to get up to the Supreme Court. There's ample jurisprudence, especially in a developed state like Florida, to address this issue. So it ain't going anywhere. And if for some reason the judge here, which state court judges haven't been particularly great for Disney lately, there's a subtext that you sort of alluded to, which I think is worth observing here. This is a nasty, piggish motion. And judges see that kind of stuff all the time. So, I don't want to overstate that, but it really comes across as form over substance and a kind of like treating the judge like an idiot.
I feel like there should have been a different draft here submitted, something else to defend Disney in this case, even a full-throated explanation that this is our tenant who has made this.
Well, let's be clear.
Error.
They're not in any way waiving that. But the point is, that's a motion on the merits. This is a procedural motion. It comes early on. And keep in mind, look at the header. If you scroll for a little bit, look at the header on the page. This motion was filed in May. Any page will do. 531. Okay, this is old news. The only reason this was picked up recently is because people are now digging through cases involving Florida, or maybe it's because the law firm that filed this has a good public relations firm and they wanted to get some heat on the judge. I don't really know the inside story on that. But in no way does Disney waive its right to make its substantive merits-based defense of why the hell are you suing the landlord because the maitre d' and the manager of the restaurant stupidly reassured someone that the allergen that was being asked about didn't exist in the food. That's not our fault. That's ridiculous. If indeed it was ridiculous, if indeed there are no facts that should implicate Disney here. And by the way, some people say, well, the restaurant has insurance for this. And then not only that, if Disney is found liable, as we were saying the other day, it is entirely likely that they have to indemnify. Mm-hmm. That the restaurant would have to indemnify Disney anyway, because even if there's a legal theory of liability that would implicate Disney, it would still be the conduct of the restaurant that was really the proximate cause. Mm-hmm. So it's not a shocking kind of motion to see, and it's written exactly the way you'd expect it to say. I don't know about saying in the same font, especially.
Right. There's a lot of language in there about underlined in bold as a hyperlink and all right. That kind of thing.
Well, and that is relevant when the issue of enforcement of a contract against a consumer and when you agree to arbitration, you are waiving all kinds of rights. So a waiver can only be knowing. And if you weren't really placed on notice of what you're waiving, you may not be able to enforce it. And Disney has some real problems in that case here. It's because the notice here is so preposterously attenuated. They did what lawyers do here, but it's a real bad look.
Well, the idea that this woman agreed to all of this, or would have the state of mind to think that while she's eating at this restaurant, because her husband happened to subscribe to Disney Plus in November 5 years earlier now, and also bought the tickets, not thinking of there being some kind of clause about all of these things. It's very complicated. And I'll be frank, it's been intimated on several other podcasts in our sphere that Disney should have just paid the money and made this go away, which is something that maybe there are so many lawsuits coming their way. And now one where the judge has refused to dismiss Julia Ormond's case against Disney and CAA over.
Disney has its insurance. Disney has insurance for this. Disney has reserves for this. Mm-hmm. But as a matter of policy, when you're a major corporation, you can't allow plaintiffs' lawyers to be under the impression that this is the kind of case that Disney would rather settle than look bad defending against, because then that's like pouring honey out on the picnic table in Orlando.
That's a very good point.
You're going to get some attention from a lot of insects.
And I have my suspicion on the law firm that should be called in cases such as that, but I won't name them in this video. With that being said, I want to say thank you very much, Ron, for being here. Do you want to tell people anything else about your channel? Although I think they know the kind of content they'll be getting now if they paid attention to this video.
I would hope so. No, really, I really appreciate the opportunity to chat with you, as always. I'm always happy if I can find a few minutes, and some days are better than others for that. But here we are. It's a lovely evening here in Clifton, New Jersey. And I would love to have people. I'm beginning to do a little bit more live streaming.
Excellent.
And keep your eye out, folks. Thank you.
Excellent. All right. With that being said, obviously, whenever we talk about the legal woes of the Walt Disney Company, it inspires a lot of comments and a lot of interaction between the commenters in the videos. Sometimes it's generally a "yeah, get 'em" kind of mentality, and that's okay too. If you want to leave that in the comments, it won't hurt my feelings. In fact, it might help the channel a little bit. Like this video if you like this video, and of course, consider subscribing to That Park Plays for all the news that should be fun.
Thanks for watching That Park Plays News. For more information, consider checking out www.thatparkplace.com. And don't forget to subscribe, share, like, and send this out on your favorite social media accounts.